It's United States. We can do it.
Good morning.
Good morning, Travis.
Question, Mr. Johnson. I asked for your pleadings last night, and it starts with a second amended motion.
Yes, Your Honor.
Is there not a original or something? I'm missing something.
There was the original motion for trial that was filed by Mr. Bruno and Mr. Evans, and then we filed one prior to having the evaluations done that raised technical issues from the record. And then we filed the second amendment one that incorporated all the other stuff. So that's the second amendment one.
This is the one I need to be looking at.
Is the one to look at. Yes.
All right.
And then we filed a third amendment one, but all it was under Rule 33 was just the affidavits of that are now already in evidence. And raised no new legal issues.
Just want to get that clarified.
And Judge, while we're doing housekeeping matters, we now have I believe it was Exhibit 9, it was going to be late file.
Yes.
The redactions to your questionnaire, and we've now conferred with counsel for the state and agreed on redactions for that, and we'd like to put that in the record this time.
All right.
Good morning.
Massey, how are you, sir?
I'm well, sir. I believe Mr. Rabin's opinion letter as well as the CB has already been submitted to the court.
All right.
You call him.
Mm-hmm.
Raise your right hand, sir. You swear to tell the truth, whole truth, nothing but the truth, so help you God.
I did. Morning, Mr. Ray.
Give me a minute to unpack here.
Oh, yeah.
Judge, if someone could give me a number of a court officer, I have a witness on the witness stand in federal court, my son is sitting there, and if there's some huge emergency, he needs to be able to call over here. What number can you call?
What's the office number?
They will
Start this here.
Wait a minute, say again? What's the, is it a prefix? Hold on, 615.
862.
Motion, you started with 6-2.
5946.
You know, Thomas has only been here 22 years. You think he can know the office number by now?
Yes. I just read I've got more.
That's his attachments. Your Honor, please.
I'm ready.
What kind of issue have you got?
Bank fraud. My client is a witness.
Your Honor, if I may pass forward the opinion letter and attachments of Mr. Rabin, as well as the affidavit of Mr. Rabin. And ask those be marked as exhibit, please.
What happened?
You're asking me if this is my opinion letter and my affidavit?
No, not yet.
Okay.
I don't think it's contested. To the judge.
Mr. Massey, this doesn't contain anything that isn't already in the record, correct? It's already, that's what I'm saying. Nothing new in this.
exhibit number straight here. Did the affidavit and the report collectively just get entered into evidence?
Yes.
Okay, that would be exhibit number 11.
Yeah,
Thank you.
Two different ones, 10A&B.
yeah, the affidavit and opinion letter.
Thank you.
10A&B.
Thank you.
May I proceed, Your Honor?
You may.
State your name for the record, please.
David Lewis Rabin.
Mr. Rabin, how long have you been practicing?
51 years.
51 years.
Yes,
You still get around pretty good?
that's right.
You a member of any legal associations?
I am
What are they, please?
the Tennessee Bar Association, Nashville Bar Association, Tennessee Association of Criminal Defense Lawyers.
And you're a member of the Tennessee Association of Criminal Defense Lawyers, that's
And,
right?
yes, Tennessee and the National.
And have you lectured for the Tennessee Association of Criminal Defense Lawyers on criminal law topics?
I have.
And have you lectured at the Tennessee Criminal Defense College on criminal law topics?
I have.
Have you received awards or recognitions of your practice?
I have.
Regarding the quality of your practice?
I have.
And are you recognized by Best Lawyers in America?
I am.
What about Martindale Hubbell?
I am.
What is your rating with Martindale Hubbell?
A rating.
Is that the highest you can get?
Yes, sir.
Have you been recognized for the quality of your legal writing and analysis?
I have.
And is that the Justice Henry Award for Outstanding Legal Writing?
Yes, sir.
And you've won that, or you've been awarded that 3 times? It appears.
Twice.
1983?
Yes, sir.
You're right, 2005?
Yes.
And the third one is the Jack Norman Award by the Nashville Bar Association.
I have.
Is your experience in the practice of criminal law limited to defense?
No.
Okay, you met an attorney general at one time?
Yes, I was with the State Attorney General's office for 3 years after I graduated from law school. I was with the District Attorney's office here in Nashville for 7 years. Then I took a year off to write my book on criminal procedure. Then I've been in private practice ever since.
Okay. And when you were with the District Attorney's office, did you have the opportunity to handle murder cases?
I did.
The insanity issue within murder cases?
I did.
Is that on the appellate level as well as the trial level?
Yes, thank you. At the appellate level, I've handled multiple insanity cases. When I was a prosecutor, I handled several insanity cases as a prosecutor.
Thank you. Are you familiar with the Tennessee Bar Association Journal?
Yes,
What is it?
yes.
What is that?
The Bar Association Journal is a magazine published by the Tennessee Bar Association, which has various articles in it of interest to attorneys and judges.
Okay, and have you published articles for the Tennessee Bar Association's Journal?
I have
One or many times?
a lot, many times.
Have you published any books on criminal law?
Yes, sir.
What are they?
I published a 3-volume treatise called Tennessee Practice and Procedures, published by West Publishing Company. The first date of publication, I believe, was 1984, and I've supplemented it every year since then.
So this is published by West Publishing Company,
It is.
and they have published your books for 41 years? Since
Yes.
1984?
Yes, sir.
Have you published a treatise entitled Tennessee Criminal Law?
That is the
That is
treatise.
the treatise? Okay.
Yes, sir.
And has that treatise been cited as authority in any appellate opinions?
At least 150 appellate opinions have cited my treatise as authority.
Have you lectured extensively on criminal law topics?
Yes, sir.
Have you ever been described as an expert in criminal law and procedure?
I have.
By whom?
Tennessee Supreme Court.
Remember the case?
I don't remember the citation.
WLODARZ? No good attempt to
I
pronounce
believe
it.
that was a concurring opinion of Justice Coke, described me as an expert in Tennessee criminal procedure.
Have you served as an expert witness on criminal matters in Tennessee?
I have.
A few or many times?
Many times, let me see, once, at least once for the prosecution, the rest, pretty much the rest for the defense, probably in excess of 10 times, maybe more.
Have you provided expert consultation on a number of criminal matters where you didn't testify?
I have.
Have you had significant experience in mental health cases?
I have.
Do you remember any examples of them right off the top of your head, like Graham?
Yes, sir. When I was in the State Attorney General's office at the time, we had the McNaughton test for insanity, and I was tasked with defending McNaughton in front of Justice Henry, and researched that and argued that, and that was the leading Tennessee case which changed the definition of insanity from the historical McNaughton rule to what we know as the ALI, American Law Institute test, which was the law for many years. That was a seminal Tennessee case on insanity, and I handled that. I handled cases in the Attorney General's office on synthetic competency, various cases on insanity-related or mental health cases in the Attorney General's office.
Did you teach classes to mental health professionals in what is now Middle Tennessee Mental Health Institute?
I've lectured to the doctors at Middle Tennessee Mental Health Institute, both are immediately following the Graham decision and then following the change of the law in 1995. They asked me to come out there and discuss this with the doctors and the various mental health professionals as to the
Was it
change of the
through
law.
the Graham case that, I'm sorry, were you through?
Immediately after the Graham case was decided, and they changed it, then I was asked to go out there and teach a lecture on what the new definition was. Then later, when the legislature changed it to the current statute, then I was asked to go out there again and talk about the changes in the law, and I did that.
Was it through the Graham case that you developed significant experience in mental health cases?
It was.
Can you estimate now what % of your practice involves mental health litigation?
At least 20%.
Do you consider yourself very familiar then with mental health litigation?
In criminal law, yes, sir, I do.
Forbes case, were you involved in it, involving a paranoid schizophrenic?
I was.
That was the Tennessee Supreme Court.
It was.
Stacy, synthetic competency.
Stacy involved synthetic competency.
And did you serve on the Tennessee Commission, Sentencing Commission?
I did for 9 years.
Did you participate in the drafting of the insanity statute in 1989?
I did.
Was that test for insanity was altered in 1995?
It was.
Has it been codified?
It was.
That TCA 39-11-501?
That's correct.
Were the distinctions between the prior statute and the current statute extensively addressed in State versus Holder, Holder?
It was.
In 1999.
It was.
Were you involved in Holder?
I'm sorry.
Were you involved in the Holder
No,
case?
I did not handle the case. The case cited my treatise.
That was one of the cases that cited your treatise
Yes, sir, it
as
was.
authority?
It did.
State versus Kelly, were you involved in it?
Yes, sir, extensively.
And State versus Flake.
Yes,
That case was out of Memphis,
it was. It went to the Supreme Court.
and that was an insanity issue as well.
That's correct. Involved a paranoid schizophrenic.
All of those cases that we talked about were insanity issues, were they not?
They were.
Are you familiar with diminished capacity?
I am.
How it differs from insanity?
I am.
Are you familiar with the right to effective assistance of counsel
I
in a
am.
criminal case?
I am.
Under the Sixth Amendment?
By the Sixth Amendment to the Constitution of the United States, and also the comparable provision of the Tennessee Constitution.
Okay. And are you familiar with the law regarding ineffective assistance of counsel,
I am.
state and federal?
Yes, sir.
Is there any significant difference?
No, sir. No, but I want to be clear that my testimony here is exclusively under the federal Constitution. I've read dozens or hundreds of cases of Tennessee, but I want to confine my opinion to the federal Constitution to the extent there is any difference in case law interpretation.
Strickland versus Washington test?
Sir?
In the Strickland versus Washington
Correct.
test, okay. And what exactly Mr. Raven, could you possibly back up from the microphone just a bit?
All right?
I think it's causing difficulty and distortion
Okay.
for the court.
I don't want to be distorted.
What is ineffective assistance of counsel?
Sir?
What is ineffective assistance of counsel? Does it involve two prongs?
Well, yes, effective assistance of counsel or ineffective assistance of counsel contemplates two prongs. First, the burden of proof is on the defendant to show that his or her lawyer was not functioning as the counsel guaranteed by the Sixth Amendment. That there was basically an objectively unreasonable behavior on the part of the attorney, either affirmatively or by omission. Once that is established, if it is, then there has to be prejudice. That's the second prong. So the lawyer could make an error, serious error, but that it was potentially constitutional harmless, with the possible exception of structural error. So, for example, if a lawyer allowed 11 jurors on the jury, for example, unless there was a waiver, that I don't know if the court would even go to the prejudicial thing. That would probably be a fundamental structural error that occurred. But short of that, you always have to show prejudice to establish ineffective assistance of counsel. They're two separate and independent prongs.
In an analysis of ineffective assistance of counsel, must you consider the range of competence demanded in a criminal case?
Yes.
Are you familiar with the range of competence required in a criminal case?
Yes, I am.
Are you familiar with the standard of care in Tennessee for lawyers in
I am.
criminal cases?
I am.
Could you give us some examples, just a few, of the care that a lawyer must meet in Tennessee?
The attorney must familiarize himself or herself with the facts of the case. The lawyer must consult with the client continuously. The lawyer must conduct investigation into the case beyond just mere discovery. And then the standard requires that the attorney have knowledge and skill, knowledge of the law, basically, in criminal law, that affects that particular case. That is the general standard of care required of all lawyers in all criminal cases.
Is there a basic rule for consideration of any defenses for your client?
Yes, an attorney, as part of the research of the law, the attorney is required to not only look at the elements of the state's case to decide whether those things can be addressed or defeated in some way, and then also the law requires a consideration of all possible reasonable defenses that could be raised and determine whether those are applicable to the case at hand.
In mental health issues in criminal defense, what are some basic rules on that? Should the attorney investigate his client's mental health?
Well, let me think about that for a minute, because that is sort of a different subspecies of what we're talking about. Because mental health cases require an assessment, first of all, of the client. You have to consider the competency of your client to be able to deal with you, because competency is one of the issues in any criminal case, but particularly if you suspect that there is a mental health issue regarding the client, then mental health becomes an issue regarding competency to stand trial and the ability for the client to consult with you and assist in the defense. So that's the first component of the duty of care in mental health cases. That is a current thing. A person could be competent today and get hit on the head by a brick and be incompetent tomorrow, for example. So that's a moving target. Then the next issue is, what was the defendant's state of mind or mental health issue, if any, at the time of the commission of the offense? So if the person had an alibi defense, if they weren't here, literally, then mental health issues might not be a factor. But if it was, then you would have to consider the mental health aspects of the case. And then thirdly, mental health aspect is also forward-looking. So if the defendant is convicted, you have to determine whether there are treatment facilities and the like that could be helpful to the defendant on a sentencing side. So it deals at 3 points in time.
And how do strategic decisions or tactical decisions made by the lawyer affect the analysis of effective assistance of counsel?
Yes, sir. A lawyer has a duty to consult with a client, not only to learn things about the case, but to assist the attorney in making strategic decisions. There are some decisions that are exclusively that of the client. For example, whether to waive a jury or not, whether to testify or not. The lawyer can't decide that. That has to be, the client gets to decide that. Once you leave that, then you have questions of what witnesses to call, the order of witnesses. So that is a collaborative process between the attorney and the client. And the law requires that you consult with your client about significant things, like whether you want to go for a lesser included offense or not, or whether you want to raise a particular defense, or whether you want to put on character evidence. So you talk to your client and explain to the client, based on your experience, what you think would be beneficial. And then if you get to a crossroads, for example, then ultimately the client could say, I don't want you to do this, or I do want you to do that. So it's a collaborative process. The duty of care requires consultation with the client about these kinds of things.
Is deference generally shown to counsel's strategic decisions or tactics?
Yes, sir. Invariably, clients will defer to the attorney, but the attorney can only make that decision after conferring with the client and understand his or her wishes. Once both options are given, and then they discuss it. But of course, there's a tremendous deferral or deference to the attorney's decision. That's why you hire a lawyer.
do tactical decisions of counsel in order to be, to deserve deference? Must they be informed decisions?
Yes, sir.
Your Honor, please, I would tender Mr. David Rabin as an expert in the area of criminal law and effective assistance of counsel in criminal cases and the standard of care required by defense lawyers in the representation of the accused.
No objection.
Give yourself declared.
Thank you. Mr. Rabin, are you familiar with the case of State versus Travis Reinking?
I am.
How are you familiar with that case?
I'm familiar with the case. I live in Nashville. I read about it in the news, wrote an article about it in the Tennessean. It was very, very, very big case in Nashville. We all lived it, and I watched parts of the trial. And so, yes, I'm very familiar with the case. Before you all hired me.
And did you follow the case before the trial?
Yes, sir.
You followed the case during the trial?
To some degree, I did.
Were you present for parts of the trial?
I was not present. I watched some of it on television.
And were you provided with materials to review on behalf of Mr. Reinking?
I was.
For what purpose?
For purposes of reviewing the record, to write an opinion letter as to my views on ineffective assistance of counsel.
And what materials were you provided? Do you recall?
Provided with the files of both lawyers, well, all three lawyers, was provided with the trial record, copies of the discovery, copies of the mental health reports, copies of the trial record, the technical record as we call it. Let me see.
File of the investigator, Mickey Rustin?
I reviewed the investigator's report. I consider that part of the file, part of the lawyer's file.
Both investigators' files, that being Janice Lee also,
Yes,
and the public defender's file,
I did. I saw that. Yes,
and Mr. Bruno and Mr. Evans' file,
yes,
as well as all the pleadings in the clerk's office
correct.
and all the discovery materials provided
I was.
and the transcripts.
Yes,
Were you able to thoroughly review these materials?
I was.
Were these materials the type of information relied upon by legal professionals in reaching an opinion on issues such as the effective assistance of counsel?
It is.
While I'm on that effective assistance of counsel, have you addressed that area in any of your books?
Yes,
And so you've written and published articles on effective assistance of counsel and ineffective assistance of counsel.
I have.
Have you lectured on it?
I have.
Few or many times?
Many times.
Have you consulted on it?
Many times.
Many times. All right. Are the opinions that you are reaching in this case to a reasonable degree of legal certainty?
They are.
I want to address you now about the issues presented in the motion for your trial.
All right.
First being insanity.
Yes, sir.
What is the definition of insanity?
Tennessee definition of insanity is codified, the current definition is 3911-501. Recites it's an affirmative defense to prosecution that at the time of the commission of the acts constituting the offense, the defendant, as a result of severe mental disease or defect, was unable to appreciate the nature or wrongfulness of the defendant's act. Mental disease or defect does not otherwise constitute a defense. The defendant has the burden of proving the defense of insanity by clear and convincing evidence.
And does both the Tennessee and the United States Constitution prohibit a mentally incompetent person from being put to trial?
Competency? Yes, yes, sir. We're now talking about competency,
Right.
which is a
I
separate thing. Correct.
Was the definition of wrongfulness at issue in this trial
It was.
of Mr. Reinking?
It was.
Okay, my questions now are going to be about Mr. Reinking.
Yes, sir.
Was this an issue of importance?
Yes, sir.
Should trial counsel have anticipated, in your opinion, the issue that was presented to the court during trial, whether all forms of wrongfulness are included, or whether it's just with the generic wrongfulness decision?
The duty of counsel was to look at all aspects of the insanity defense, all the components of the insanity affirmative defense, one of which is wrongfulness.
Did that appear to have been done here?
What are you, restate your question.
I did an investigation into did you see the research files of counsel?
I did.
Was there anything in the research files indicating a research of wrongfulness?
There was research on several Tennessee Supreme Court cases dealing with insanity, some of which discussed wrongfulness.
When you look at Reinking, I'm sorry, were you still about to say something else? No. Okay. When you look at Reinking, what is the defense that immediately comes to your mind?
Insanity.
And does that issue have an extremely high potential of being outcome determinative in his case?
It does.
Was that the defense that the lawyers presented?
It was.
Should trial counsel have, now they objected to the wrongfulness instruction given by the judge.
They did.
Should they have submitted any kind of authority
Yes, sir.
to Judge Fishburne?
Yes, sir.
Did they?
No.
Should there have been should this issue have been anticipated? I believe you said yes earlier.
Yes.
And should an alternative jury instruction have been prepared?
Well, yes, sir. I'll just answer the question is yes.
Was that the best practice anyway?
It was.
Did you find that this failure to anticipate and provide the issue arising and the failure to present the court with authorities, did that fall below a reasonable standard in Tennessee, an objective standard?
Yes, sir. And there are two issues on that, on the special instruction, if that's what you're talking about.
I'm talking just right now about the wrongfulness issue.
The wrongfulness, yes. In other words, if there is a disagreement as to what the definition of wrongfulness should be, or if there is an alternative suggestion of what the definition should be, it's incumbent on the attorney to either object to the one that's given or to submit a special request as to what the lawyer believes it should be. If the judge denies it, then that issue can be litigated on appeal, which is the point of special requests on that issue, just on the wrongfulness. There's another issue, but I'll just limit my...
And counsel did object.
Did not.
He did. He objected on the wrongfulness, he did. He objected to the wrongfulness instruction given by the court.
Right. An objection under Tennessee law, under standard of care, requires not only an objection to a jury instruction, but that the lawyer is required to have a corollary special request as to what what the judge might or should instruct the jury.
And that was not done.
It was not done.
Okay. Did that fall below the objective standard of care?
Yes, sir, because at that point you waive any attack on this, on the definition by failing to do that, so that you can't litigate it.
Let's talk about the other jury instruction issue with insanity. There was the conviction first and then insanity last consideration, jury instruction given. I believe the court told the jury, however, you are to consider this affirmative defense if, and only if, you have first found Mr. Reinking guilty of one or more of the offenses contained in the indictment. You recall that?
I do.
And does this instruction, does it tell jurors they've got to find him guilty to find him not guilty?
That's what it says.
Are you
Well,
aware
it
of any
says-
law in
it said that
Tennessee?
You have to make a decision on murder first, second, et cetera, on the guilt phase. And then, only then are you to consider the affirmative defense of insanity. That was the instruction.
But the effect of it was to say you have to find him guilty before you can find him not guilty by insanity.
You either find him, well, if you acquit him of first-degree murder or homicide, that ends it. But if you have to render a verdict on that, then you go to the affirmative defense. It's sequential
Right.
jury consideration. That's what it says.
Are you aware of any law in Tennessee supporting this instruction?
There is no such law.
Is this instruction contrary to settled Tennessee law?
There is no law in the state of Tennessee which contemplates a conviction or acquittal first before you consider an affirmative defense. I have an opinion as to whether it violates law, but I will begin by saying there is no law in Tennessee that contemplates that the jury must first consider guilt or innocence on the charged offense before they consider an affirmative defense. There is no statute or case law that says that. I have an opinion about the effect of that, but that's a separate question.
Does the burden of proof statute 3911-201, does that address this situation at all?
The burden of proof statute talks about what the state has to prove beyond a reasonable doubt to convict of any offense. And it goes through, it has to prove the mens rea, has to prove not causation, but negate defenses. Affirmative defenses are not raised in the burden of proof statute. That's a separate statute. But that statute, the affirmative defenses follows that statute in sequence.
There's no verbiage in either one of those statutes that indicate there should be a finding of guilt before considering insanity.
There is no law in Tennessee state, there's no statute or case that says that.
In your professional opinion, did this conviction first, insanity last instruction compromise Mr. Reinking's right to a fair trial?
May I answer this question this way? I'm here to give an opinion on ineffective assistance of counsel. I can give you an opinion as to whether the lawyer's failure to object to that constituted. It did. The lawyer should have objected to it.
There was no objection to this?
No, well, and I'll answer the question this way.
Okay.
Ineffective assistance of counsel requires a consideration of the lawyer's failure to do something. Here, there was no objection to that instruction. If you look at the prejudice prong, on that, I can give you an opinion that he was prejudiced because, in my opinion, it violated his constitutional right to a fair trial under the Sixth Amendment. So I analyze it under the prejudice prong, not in the abstract, what the lawyers say, whether it violates some constitutional right or not, that's for y'all to decide. I'm up here only talking about ineffective assistance of counsel on the prejudice prong. On prejudice, it absolutely prejudiced the defendant's right to a fair trial and the right to a jury trial, not just a fair trial, but a jury trial, because it compelled the jury to consider the elements of the offense, etc., completely separate and apart from whatever might have been the issues regarding insanity. You don't bifurcate those decisions because the mental health, the definitions of premeditation and all that have a lot to do with the defendant's state of mind. So theoretically, I mean, the jury could have just walked in there and say, well, he's insane, we're gone, we're done. We don't even have to consider anything else, if that was the prerogative of the jury. But I think forcing the jury to consider guilt or innocence first in isolation from insanity. The law is pretty clear that juries are presumed to follow the judge's instructions. So if you indulge yourself in that presumption, that's what happened. The lawyers should have objected to that, and I find profound prejudice.
So they had is it fair to say the lawyers had a duty to object to that jury instruction?
Absolutely.
And they failed to object?
They did.
And does that meet the defective performance prong of ineffective assistance of counsel?
That affects the affects the performance prong.
Okay? And there is prejudice to Mr. Reinking by that defective performance, professional errors.
In my opinion, yes, sir.
Is the error harmless?
No.
Why?
In my opinion, I think that error could conceivably be considered structural error, like allowing 11 jurors instead of 12. I think once you get into telling the jury what they have to consider or not to consider before they consider a constitutionally cognizable defense, could conceivably be considered structural error. But if you don't consider it that, harmless error, in my view, this could not be constitutionally harmless. The burden of proof showing of constitutionally harmless error is on the state. Even if it's not a constitutional error, since the whole case, the way it was tried, was nothing but insanity. That was the only issue. So, therefore, if the judge failed to give an instruction on witnesses or credibility of witnesses or something like that, you can make an argument all day that that's just harmless. But on fundamental thing of telling the jury how they're supposed to consider or not consider something, that could not be harmless in this case, given insanity was the only defense.
We'll move on now to diminished capacity.
Yes, sir.
What exactly is diminished capacity?
Under Tennessee law, diminished capacity is a rule of evidence, allowing the defendant to introduce evidence that he or she did not possess the intent, and technically the specific intent, to commit the offense.
Okay. Kind of two prongs on diminished capacity as well?
Well, you have to consider what mental state you're assailing or that you didn't have, and but that's what it is. It's a rule of evidence, and then what happens is, then if you introduce that evidence, then the judge instructs the jury that you're to consider that in deciding whether he or she possessed the requisite mental state to commit the crime. So you have two issues. One is evidence, then the other is a jury instruction, which tells the jury how they're supposed to consider this evidence in deciding whether the defendant is guilty by potentially removing one or more mental states of the charged offenses. That's how it works.
Where is diminished capacity most often used in a homicide case?
To assail premeditation.
Was there sufficient diminished capacity, in your opinion, reviewing this record, to establish diminished capacity?
Yes, sir.
Certainly the duty to investigate diminished capacity.
Yes, sir.
So was premeditation an issue in Mr. Reinking's case?
It was.
Does diminished capacity require any analysis of the wrongfulness, ability to appreciate the wrongfulness of your conduct, in legal or moral, like the insanity defense?
Let me separate those two issues. When you're talking about insanity and wrongfulness, the person's ability to be aware of the wrongfulness of his or her conduct is an issue. Diminished capacity assails the premeditation aspect, whether or not they can prove that the person premeditated the crime. So diminished capacity, if you're asking the question technically, both require mental health testimony. Both deal with this defendant's state of mind. Without question, they are related evidentiary-wise. But from a jury instruction standpoint, the jury about insanity and whether that's the defendant can prove it. And then if it's properly presented to the jury, then the jury considers diminished capacity in the context of guilt or innocence. And in this case, because they were considering the charged homicide first, then there was no diminished capacity in play there, and in my opinion, it should have been.
Mr. Reinking was clearly delusional and thinking that Taylor Swift was stalking him and that there were aliens and CIA and FBI involved in tormenting him.
That's what the medical records showed.
Yeah. And does that delusional thinking, would that put reasonably effective lawyers on notice that they should look at a diminished capacity?
Yes, sir.
Do you find any evidence that these lawyers did look at diminished capacity?
I've reviewed the record and I can answer your question specifically.
Okay.
The evidence is that neither attorney discussed diminished capacity as part of the strategy. Mr. Evans testified yesterday. No one ever mentioned, like we should argue diminished capacity. That was never talked about as part of our strategy. Paul Bruno testified yesterday. I do not remember talking about that topic. I don't remember us having any kind of discussion about it. Well, we can alternate with the diminished capacity. Testified that that diminished capacity issue was never discussed with the client. And he said, we never discussed with him that we can argue alternatively diminished capacity or look for second-degree conviction or something like that. No, I don't ever recall sitting there with him and talking about it. That's what the record shows. And there's nothing in the lawyer's files. I looked for that to see if that was in their notes, if it was in their research file, if there was anything in there. And it was not. And it was not until yesterday's testimony that I saw that, in fact, the proof is they didn't consider it. They didn't consider it.
Under the facts of this case in Reinking, and given the delusions and the medical proof, did counsel's representation fall below an objective standard of reasonableness in Tennessee by not pursuing an investigation on diminished capacity?
Yes, sir. There was objectively unreasonable performance on the part of the lawyers in not investigating and presenting that to the jury for their consideration.
would diminished capacity have an enormous value to Rinking's defense, Mr. Rinking's defense?
Yes, sir. I can, if you want me to articulate that, but the answer is yes. It had an enormous impact on his case.
First, in the burden of proof, is there a burden on the defense regarding diminished capacity?
There is a burden of production requirement on the part of the defendant. The defendant has to advance evidence of diminished capacity, either through cross-examination or affirmative evidence. Once that's in play, that's a burden of production. Then the burden of proof is on the state to prove here premeditation. And so what happens there is you are negating an element of the state's case. So in this case, you are saying the state cannot prove premeditation. So the burden is on the state. So diminished capacity, the value of it is, unlike insanity where the defendant has all the burden, here you're saying the state can't meet its burden. So you have a tremendously different burden shift by advancing diminished capacity.
Is it fair to say that diminished capacity could be a fallback position to insanity?
It is, you could use it that way, depending on how you want to characterize it, fallback position, alternative, but under the judge's instructions here, if that the way the law was, you use diminished capacity to assail premeditation and say, well, you're supposed to consider guilt or innocence first, so let's talk about diminished capacity and try to take out premeditation. And so the way the case is structured, that would be the only way to do it. And so although things are considered in tandem, technically here you would want to use diminished capacity to attack the premeditation component of the first-degree murder charge. That wasn't done.
And can an expert give an opinion on whether or not, on the ultimate issue of whether or not Mr. Reinking could have formed the requisite mens rea?
Under Tennessee law, an expert can give an opinion on the ultimate issue of a premeditation or diminished capacity. The law permits that.
Would an argument to the jury during this trial for diminished capacity, would that in any way diminish the defense of insanity?
No,
As a matter of fact.
they are. They're not compatibility. You would want to, and I'll answer the question in terms of effective assistance. No lawyer would present an insanity defense and an alibi defense. Well, I wasn't there, but if I was crazy or something. Those things are so inconsistent as, to be unreasonable, I suppose. But when you're dealing with issues of diminished capacity and insanity, they're entirely compatible. So yes.
So the delusions that Mr. Reinking would have, it could support a lesser included offense?
Yes, sir. The lesser included offense is based on this record. In my opinion, the delusions were so profound that if you take out diminished capacity in play, then it reduces it to second-degree murder. If you read the definition of premeditation, which talks about passion and excitement, that's the stuff of manslaughter. So conceptually, you could have a lesser included offense of second-degree murder or arguably voluntary manslaughter, but no lower.
The facts were present to make that argument if diminished capacity were presented to the jury. Would you agree?
It was. And of course, the difference, of course, being the punishment. I mean, life whether it's life without parole or just straight life, it's 51 years. It's no functional difference. The second-degree murder carries much lesser time, and of course, so does voluntary manslaughter at the time.
Is there a Tennessee pattern jury instruction on diminished capacity?
There is.
Did counsel request a jury instruction on diminished capacity?
They did not.
Should they have under these facts?
Yes, sir.
Why?
Because I think even if the witnesses hadn't used that phraseology, I think that there's enough proof in the record here about the defendant's state of mind, et cetera, that you could have arguably talked about a lack of premeditation, at least to the point of putting in a jury instruction on diminished capacity. Would have raised the issue. The judge may have denied it, but that could have been an appellate issue. But without question, I mean, the case law is pretty brutal on that, I'll be honest with you. The case law does require expert testimony pretty much on this, but you had experts who were testifying about his state of mind. So I think there's enough in the record that they could have instructed it. That surely the standard of care would have demanded that they put that in. And I think given the record and the magnitude of this case, the judge may have granted it. Certainly would have been an appellate issue, but absolutely, in my view, they had a duty to present that as a special request.
And the failure to either investigate or present or ask an objective standard of care in Tennessee.
Yes, sir.
Any question about that to you?
There is no question in my mind about this. Mr. Massey, I've been practicing law 51 years. I've handled a lot of these cases, and I'm telling you that that was an absolute, in my view, professional failure of the first magnitude in a case like this, because they never considered it. It was very viable, and they never talked to Mr. Reinking about it, which is another duty of a lawyer to talk to the client about it. Mr. Reinking said, no, I'm not going there. I don't want to go for manslaughter. I don't want to go for second degree. I don't want anything to do with it. And there are cases where that's happened. Then my client tells me that, then I'm not going there. But that never happened. They never left it to the client. They never discussed it with him. And that is fundamental error in my view of ineffective assistance of counsel. You have an absolute duty to talk to the client about something like that.
There were requests made and orders issued in the General Sessions Court to evaluate Mr. Reinking's mental health and his competency, correct?
There was.
In fact, the mental health issue was directed toward insanity. They were instructed to look at insanity and competence.
They were.
Initially, did you find that Mr. Reinking was not competent?
The record reflects that the doctors found he was not competent to stand trial initially.
To not be competent to stand trial, how messed up does your mind have to be to not be competent to stand trial?
There are two issues of competency. One is the ability to understand the court proceedings, and the second is the ability to consult with counsel. I've had an attorney who certainly understood the court proceedings, but the attorney was so delusional that he was not able to assist me in defending the case, couldn't explain the case to me. So you have to be profoundly disturbed not to be competent.
And did the records indicate that Dr. Wood and Dr. Eisen found that he was unable to appreciate the wrongfulness of his conduct as well?
We're talking about wrongfulness now.
I'm
Let me
just asking
flip
the
over to
second.
that.
Mhm.
Okay. That's true, yes, sir.
So, in consideration of Mr. Reinking's mental health state, this incident occurred on April 22nd, 2018. He's arrested the next day, on April 22nd, 2018. 4 days later, an outpatient order was entered. And eventually, the doctor's reports were provided. You've seen those doctor's reports, Dr. Eisen and
I
Dr.
have.
Wood? And does your review of the materials indicate that when Mr. Bruno and Mr. Evans came onto the case in June of 2019, June 29, 2019, they subbed in for the public defender? Had any further investigation been done
On what?
on the issue of competency or insanity or any other mental health condition like diminished capacity?
There was not.
Once counsel had these records in their possession and had access to those records, would that put reasonably competent counsel on notice to investigate further?
Yes,
Are you familiar with what the standard of care is in Tennessee when requesting an evaluation of mental health?
I am. The standard of care dictates that if not at the general sessions level, but certainly at the criminal court level. In Nashville, I'll explain it this way. In Nashville, we have a two-tiered system. You go to general sessions court and you ask for a mental health evaluation on competency and state of mind. Professionally, I typically will ask for a diminished capacity in the general sessions level. That goes over to Vanderbilt. They give you an opinion, but it's only a preliminary decision. They don't make a conclusive decision. But they can recommend, or they can just say, well, the person's competent, there's no mental health issue, we're done. Or they can say there's enough of an issue there, the person needs to go to Middle Tennessee. At that level, the criminal court then issues another order ordering the person for a forensic evaluation, at least a 30-day evaluation. Standard of care requires competency, mental health, sanity, and diminished capacity to be considered at Middle Tennessee Mental Health. At that level, that's what the standard of care dictates, and that's what lawyers do, or should do.
Standard of care requires lawyers to ask for an evaluation of insanity, of diminished capacity, and competence.
At least post-indictment, yes, sir.
Was that done?
No.
Counsel, as I said, came on the case in the circuit court, in the criminal prosecution, trial level court, in June of 2019. And could they have asked for further evaluation?
Yes, sir.
Is there any reason not to? I mean, any reasonable reason not to?
Under this record, there is no reasonable reason under this record. If the evaluation had occurred a week before the lawyers came on, probably not. But it had been years before Mr. Reinking had had any kind of evaluation. So under this record, there was an absolute duty to have him evaluated further by mental health professionals, given the significant passage of time.
And did counsel's conduct or representation fall below the objective standard of reasonableness for not further investigating diminished capacity?
Diminished capacity?
Yeah.
Well, all three. At that point, there was no evaluations for competency, insanity, or diminished capacity by the lawyers when they came on. All three prongs, there was deficient performance. There should have been another mental health evaluation by a psychiatrist once they came on, addressing all three of those components.
And their failure to do so fall below an objective reasonable standard required of lawyers in criminal cases?
Under the facts of this case, in my professional opinion, that fell below the objective standard of care of lawyers in criminal cases in the state of Tennessee.
So as of June 29, 2019, when Mr. Bruno and Mr. Evans came aboard this case to represent Mr. Reinking, diminished capacity had not been evaluated, had it not?
The lawyers never considered it either then or at any time. Either one of them collectively or discussed it with the clients.
And the trial did not occur until some 2.5 years later.
That's true.
Was there time to do that mental health evaluation?
There was.
Are all three of those, insanity, competency, and diminished capacity, are they generally done at the same time?
They are.
So no extra really work, I guess. There's no reason not to ask for it.
You ask the judge for an evaluation. If the judge refuses, then you ask for resources to do it yourself. I could not imagine in my wildest dreams the judge wouldn't have authorized that in a heartbeat. Or you could have had your own private mental health people do it, of course.
Okay.
It was, in my opinion, it was, under the facts of this case, it was imperative that that be done after they came on board, particularly given the passage of time, especially given the passage of time.
Sometime within that 2.5 years of having the case, they should have had him reevaluated and evaluated for diminished capacity?
Yes, sir.
And possession of the findings of insanity, inability to appreciate the wrongfulness of his conduct, and the finding that he was incompetent when he was arrested, right after he was arrested. Did that put lawyers on notice that they need to do further investigation into mental health? A complete investigation.
The answer to the question is yes. In this particular case, you had evaluations at the outset. One was done by Vanderbilt, then one was done by Middle Tennessee Mental Health. Given the passage of time, and particularly the available information was significantly more, and that's why I find in my review of the evidence there was the failure, because the doctors at Vanderbilt, and they're good doctors, and the good doctors at Middle Tennessee, they had X amount of information. But then you had discovery. The lawyers were armed with far more information, tapes of the shooting, videotapes, all kinds of things that were not in hand, or may not have been in hand, or hadn't been analyzed correctly. So that years later, you have a much larger bucket of data. You can have interviews with family members. You have interviews with other people. You have all the evidence that the state presents in discovery, which you don't have initially. You give that to the doctors and say, well, what about this? And what about that? So you have a much richer database to make an assessment with. So even that alone would have dictated an additional evaluation.
Would have what?
It would have dictated a greater evaluation because you had a bigger bucket of data to look at. So another evaluation would have been in order because the information was much more fulsome years later than it was a few months before, after the shooting. So that alone, but then you also have the passage of time. So it's a long answer to a short question, but absolutely under this record, you should have had another evaluation.
And you're aware that Mr. Reinking was declared indigent,
He was.
so this testing would have been covered as a necessary investigation by the court. It wouldn't be an extra cost to Mr. Reinking, would it?
That's true.
So cost would not be a deterrent?
No.
here?
No,
And-
not in this case, under these facts. If they had asked for an additional evaluation, I can't imagine it would have been denied. It wouldn't have cost anything.
You said that further psychiatric evaluation should have been requested, right?
Yes.
What about neuro psychiatric evaluations?
Now that I've read everything, yes, it should have been done. Because you're talking about the difference between behavioral abnormalities or mental health abnormalities. If you're looking at neuro evaluations and you're looking for organic deficiencies, which is something that needs to be investigated, which I understand apparently was in the post-trial proceedings.
So neuropsychological testing should have been done as well.
Yes, sir. I mean, Mr. Massey, if the lawyer's saying that their whole defense is insanity, if that's the only horse they're gonna ride on, then you get a big horse. That's what you do. You put as much evidence as you can on that, including psychological, neuropsychiatrist, or whatever. If that's what you're gonna do, then you have as much information and testing as you can on that issue.
Is it fair to say that under the facts of this case, and what you've read from Mr. Bruno and Mr. Evans in their testimony earlier in this proceeding, was their decision not to look at diminished capacity and have further evaluations on all three issues, but diminished capacity I'm directing this toward, can that be an informed tactical decision?
Okay, let me take this one at a time, okay? That is not a tactical decision. Those are called strategic decisions, okay? Tactical decisions are whether you're gonna call this witness or that witness in the orders, that kind of thing. Strategic decisions are whether you're going to explore competency, whether you're going to go with diminished capacity, whether you're going to go with insanity. Those are strategic decisions because they impact the case in its entirety. And so there has to be an informed decision to make. In my review of the record, there was no strategic or tactical decision made regarding diminished capacity. It was never considered. So you can't say whether it was tactically or strategically appropriate in this case because they never thought about it, never discussed it with the client. So it was not an informed decision. That is the point, that if they sat around and talked about it and the client said, I'm not going there or whatever, then that's fine. Then that's an informed decision. And right or wrong, if it's an objectively reasonable decision, it's not ineffective assistance of counsel. Not to have further mental health evaluations on insanity, et cetera, in my professional opinion, that was objectively unreasonable and was not an informed decision. The failure to have further competency evaluation, I cannot and will not give an opinion on that, sir, because I don't know the answer. I don't know. We don't know as we sit here whether the defendant was competent or incompetent during the trial. And that would be because the burden is on the defendant, because there was no evaluation. I can't tell you whether he was competent or incompetent. Surely the standard of care would have dictated for the person with that mental illness, let's have another evaluation to make sure he's hitting on all fours when he's in the courtroom. But because I don't know, we just don't know. We know he was incompetent at one point, and we believe now he is. But as to whether he was competent or incompetent while his trial was going on, I couldn't possibly tell you. Should that have been looked at? Yes.
I understand about competency, okay? But
Right.
I'm asking now about really the ability to form the requisite mens rea
Now, you're talking about diminished capacity.
and diminished capacity.
So what is the question there?
That, given the history of this case and the facts involved in this case,
Right.
his delusions, would reasonably competent counsel have been on notice to investigate
Yes.
diminished capacity?
Yes,
Is that huge in this case?
absolutely.
Is the need for that glaring in this case?
It is.
Or his delusions, I think you said in your opinion letter, the stuff of diminished capacity?
Yes.
And have you been involved in a number of cases where diminished capacity resulted in a lesser included offense verdict from the jury?
It, let me answer that.
It's not a
Wait,
defense,
let me
okay?
think about that. Where I've had diminished capacity, a profound diminished capacity, in my experience, the vast majority of times it results in a plea to a much lesser included offense. And I've tried cases where I've used diminished capacities or variations in it, and they've been lesser included offenses, but I don't know exactly how that all played out with the jury, but certainly I've had many cases, a lot of cases, where I've advanced a diminished capacity and was successful in getting a plea agreement to a lesser included offense.
Would you agree that there's an abundance of case law where the facts involved delusional defendants and there was a lesser included offense found by the jury?
There
Were
have
charged
been.
with first degree?
Yes, in
A
Tennessee.
bunch, right?
Sir? There have been several.
Okay. Last time I'll ask this, I hope. Did the failure of trial counsel to have further mental health evaluations conducted on Reinking fall below an objective standard of reasonableness in Tennessee,
It did.
particularly regarding diminished capacity?
You're asking me the prejudice prong or the performance prong?
Both.
The first, okay, on diminished capacity.
Let's do the prejudice prong first, because I'm going to ask you about prejudice. I mean, the defective performance first.
The first is defective performance. The failure to investigate or put on evidence of diminished capacity fell below the standard of care, so you have a defect there. Was the defendant prejudiced? In my opinion, he was.
And what prejudice, did you find prejudice?
I did.
And what would that prejudice be?
The prejudice would be that the jury never got to consider whether or not the defendant possessed the requisite mental state of premeditation under the facts of this case, given the definition of premeditation under Tennessee law. They never got to consider that as it relates to a mental health defense of a doctor saying he didn't have the requisite mens rea to form premeditation under the law of Tennessee. And he didn't have that, and I suggest that that was profoundly prejudicial because there was, in my view, there was just overwhelming evidence of mental disease defect that would have had impact on diminished capacity, either to take it down to second or possibly manslaughter, conceivably.
Well, second degree for sure,
Well, yes,
If it
and then
knocks out
arguably
premeditation.
manslaughter.
then
Right,
second degree is the next consideration, right?
right.
Is,
The jury never got to consider it. There was a tremendous amount of evidence that would have supported it. And in my view, then, the defendant was prejudiced because he didn't have it. If you look at diminished capacity as a defense, it really isn't, but theoretically it could be conceived of as that way. They're deprived of their constitutional right to present a defense, which negates the state's evidence.
And so under the facts of this case, do you find, is it your opinion that there's a reasonable probability, but for counsel's unprofessional errors, that the result of the case, the outcome would be different?
Yes, sir. Basically, the standard there is, that's the end of the decision-making process, is whether or not the result would have been different or reasonable possibility of a different result. The possibility, the Zimmerman case holds that the possibility of being convicted of a lesser included offense, not an outright acquittal, is sufficient to undermine confidence in the outcome of the verdict, which constitutes an ineffective, a Sixth Amendment violation.
On the issue of competency to stand trial, I believe you said that there was no further evaluation done regarding competency to stand trial.
There was not.
Was there a sufficient passage, a significant passage of time between the incident and the finding that he was initially incompetent and the trial?
And what is the question?
So it was about 5 years or so
It
that
was.
nothing was done, or 4 years?
Right, I'll answer the question this way. It was deficient effective assistance. It fell below the standard of care not to have another evaluation. Whether or not the defendant was prejudiced or not, I cannot tell you. I cannot render an opinion on that.
It's a moving
Because
target,
I
right?
don't know. But,
It's a moving target, competency issue.
well, it's a moving target, but because it wasn't done, there's nothing for me to analyze. So,
Should it have been done?
of course,
Did it fall below the standard of care in Tennessee for it not to be done?
it did.
Just for clarification, are you limiting that to the competency issue?
The competency issue only, Your Honor.
That's what I want to clarify.
On the competency question, professionally, they should have asked for it under this record. Was he prejudiced or not? I cannot say, because it's a moving target. There's no evidence one way or the other. On diminished capacity and insanity, both prongs are met in my view.
Got it.
And would counsel have a duty to investigate that?
Which, what?
Trial counsel, would they have a duty to investigate competence before trial, given the significant passage of time?
Yes, sir. And that's why I'm saying they fell below the standard of care, because they failed in that duty. But whether it prejudiced him, I have no opinion, because I don't know.
All right, I want to move now to counsel's failure to anticipate and file a motion in limine to prohibit comments on defendant's request or questions on defendant's request for counsel when he was arrested. Okay?
I reviewed that issue.
Okay. And there was an objection made at trial regarding that matter. Was there not?
There was.
Is it fair to say that it's settled law that the state must scrupulously avoid any mention of a defendant's exercise of his constitutional rights to remain silent or consult counsel?
Generally speaking, that is true. That's correct. Generally speaking, there are some limited exceptions, but that is correct as a general proposition.
And does the record indicate that during the trial, the state did ask that question in the presence of the jury?
They did. Of the mental health expert specifically. Question was, giving an opinion about his state of mind, and that he, right after he was arrested, that he asked for an attorney or words to that effect. There was an objection. Then there was an instruction dealing with that, which we'll get into in a minute, but that's the state of the record.
I think a motion for mistrial was made as well.
It was.
It was denied.
It was.
And a instruction was given to tell the jury why they could use this or how they could use this piece of evidence that he asked for a lawyer.
There was an instruction by the court on that issue.
In a case where you're running the insanity defense, how harmful is it to that defense that evidence was allowed into this case regarding his request for a lawyer, when wrongfulness, knowledge of the wrongfulness of his conduct is in question?
Well, and generally speaking, that is an issue that no lawyer would want into evidence for any reason that I can think of. And so that is something that the lawyer should have objected to, or not only objected to, excuse me, should have anticipated and filed a motion limiting to keep that sort of thing out.
1 minute, please. Okay, the limiting instruction given to the jury read, members of the jury, before we start again, I'm going to give you a limiting instruction on what is about to occur so that you fully understand how you can utilize the evidence that I suspect is forthcoming. A person charged with a crime has an absolute constitutional right to an attorney, even if he hasn't yet been charged with a crime. If he's in custody, he has a right to an attorney. When an individual requests an attorney under our Constitution, you, the trier of fact, the jury, cannot under any circumstances use that against him in any manner whatsoever, suggest that he must be guilty of a crime, whatever, along those lines, okay? As a general rule, even asking such a question is improper. And that's why I stopped it at this point in time. In the circumstances under which the issue that is at trial in this case, as to whether or not Mr. Reinking appreciated the wrongfulness of his conduct, you could consider only on that issue, not whether or not he's guilty, but on the issue as to whether or not his request for an attorney gives insight into that issue. It's one of all many circumstances that you can and must consider, but he has an absolute right to an attorney, and under no circumstances can you use it against him for constitutional purposes of protecting his rights under the law as to guilt or innocence. But it can be used for the very, very limited purpose of evaluating whether at the time he understood whether or not his conduct was right or wrong. That purpose and that purpose alone. I believe I asked you earlier if the injection of his request for an attorney would be harmful to his defense of insanity.
It was.
And is that, did this jury limiting instruction, did it Did it ameliorate that harm? Did it mitigate that harm that was done, in your opinion?
It did not.
Do juries understand those nuances in the law, in your experience? For example, in the circumstances under which the issue that is at trial in this case as to whether or not Mr. Reinking appreciated the wrongfulness of his conduct, you can consider only on that issue, not whether or not he's guilty, but on the issue of whether or not his request for an attorney gives insight into that issue.
All right, let me answer the question this way.
I'm sorry?
I'm gonna answer your question about, you said
Go
what
right
the
ahead.
juries understand or what they don't understand.
All
I couldn't
right.
pretend to tell you what a jury understands or doesn't. On the question you asked me, whether or not that ameliorated the problem, again, I'm not here to talk about legal issues. I'm here only to talk about effective assistance of counsel and the duty of the attorney. Here in this particular case, the lawyer was on notice from the discovery that the client had invoked the right to counsel. It was in the newspaper and it was in the discovery. Professional standards require that the lawyer have anticipated that and filed a motion in limine to keep that out and to cite the Supreme Court of the United States, which holds that unequivocally is inadmissible for any purpose, guilt or innocence or mental state. The lawyers failed to do that, were professionally unreasonable and fell below the standard of care to have anticipated that. I cannot find a case that shows a failure to file a motion in limine is ineffective assistance of counsel per se, but I'm saying under the facts of this case, given that it was all or nothing, according to lawyers, that was a devastating piece of evidence to impeach a doctor with, sir. And then they objected to move for a mistrial. Now, those lawyers didn't have this Wainwright versus Greenfield case, which is a standard, well-known case. The United States Supreme Court makes it pretty clear. They didn't have that. That wasn't in the research file. Be that as it may, when the judge's limiting instruction was given, they had an absolute duty to have objected to that, because to tell the jury that it has no bearing on his guilt or innocence, fine. That's okay. That cured the error, I suppose, on the guilt or innocence. But on insanity, it says you can consider it on the only defense this man has as to whether he knew right from wrong or whatever. You can consider his invocation of counsel on that. In my professional opinion, the lawyers had an absolute obligation to go to the mat on that one and say, no, please don't charge that, and object to it. And then what's worse is the prosecutors got up and argued to the jury that same thing. You know, they attacked the lawyer, the wrongfulness thing, because look what he did, he asked for a lawyer. That was devastating. It was devastating, Mr. Mayor. That it absolutely should never have happened. The lawyer should have anticipated that. And if they didn't, then they should have had to ask for a limiting instruction that it shouldn't have been considered for any purpose. But to say that it can be considered for insanity, and the lawyers didn't object to that, was ineffective assistance of counsel of the first magnitude. And it prejudiced this defendant because the only defense he had was insanity. And for the jury to be told by the court and the prosecutor that you can consider that on the wrongfulness, to me, that's prejudice of the first magnitude. That to me, if I had to, when I get to the end about cumulative error, that's about number 2.
We'll get to that.
Yeah, but that's the problem here. Is the lawyers knew it, they didn't object to it pre-trial, and they didn't object to the special instruction, and they should have vehemently. And then when the prosecutor got up and argued about that, they should have objected to that, but by then.
You
case
talking about
law-
closing argument?
Yeah, but again, let me just say this. If the judge lets something in evidence, closing argument, I don't know if you have a duty to object to something that the judge has already let in to preserve it. Best practices indicate to that, but that's a separate issue. But just on the pure prejudice, when you look at the prejudice prong, Mr. Massey, courts look at it in almost a reverse harmless error. If an error comes in, is it magnified in some way? If the judge magnifies it by whatever the instruction was, and the prosecutor magnifies it, then the significance of the thing becomes much more profound. And so that's why I'm saying that the prejudice prong of that is overwhelming in my view.
Did you see that Wainwright versus Greenfield, United States Supreme Court case, was cited to His Honor as authority at trial?
It was not.
Does that case specifically hold that as a matter of fundamental due process, the state may not use an accused's silence or request for an counsel as evidence to rebut a defense of insanity?
It's exactly what it holds.
Should counsel have anticipated this proof?
In my professional opinion, it fell below best practices. To say that it fell below the standard of care, perhaps, maybe in a case of this magnitude, but cannot. The fact that they were on notice that it happened, if it was something they didn't know, maybe, but they knew it. And in this case, the prosecutors were very vigorous. They were using every tool within their arsenal, appropriately, that they did. They acted professionally. How could you not anticipate something
And I
like
believe
that?
that you made an attachment to your opinion letter. Those attachments are on page 36 and 37 of it that show the comments made in the news and made in a police report that counsel had in their file.
They did. They knew it.
So they were on notice that
Yes.
would be an issue. Had a properly filed motion in limine, properly researched, citing Wainwright had been given to this judge, you think there's a good chance that instruction, that evidence would not have been admitted?
I don't want to speak for the court. I would say that given the state of the law, and Judge Fitchburn is a very studious lawyer of the Constitution, I think that issue, I've had that issue come up in other cases, and I have filed motions in limine myself on issues exactly like that, or very similar to that, in high-profile cases, and there's never been much of an issue about that.
Let me ask you, when you reviewed counsel's file, did you find any evidence of research on that issue of the request for counsel?
No.
Does the lawyer have a duty to conduct legal research on a fundamental issue in the case?
He or she does. Once you have the evidence in front of you that such a thing happens, you have a duty to research it.
And you find that Mr. Reinking was prejudiced by this failure to anticipate and, but because he didn't anticipate it, the jury heard it, right?
Yes. Let me answer this way. The prejudice came about, it should have been raised pretrial, but just put that aside for a moment. Once it came here, they moved for mistrial. That was appropriate for them so they asked for mistrial. I mean, it's the ultimate sanction. But then to not object to the special instruction or limiting instruction. That was the prejudice. But, I mean, whether or not that should have ever come in or not, that's a trial issue for the lawyers to raise. I can't give an opinion about that, and won't.
You find that there's any basis for any strategic decision or tactical decision on the part of counsel not to have raised this?
It was
Pre-trial.
not considered, it wasn't strategic, it was not tactical. Nobody ever considered it. And so I don't ever get to the question of whether it was objectively unreasonable, because they never thought about it or never considered it.
I want to move now to the issue of failure to properly object to the state's proposed jury instruction about treating critical evidence for the defense as hearsay.
Yes,
Given the state of the law, what the special jury instruction says is hearsay is not substantive evidence and should not be used as proof of the underlying facts the expert is basing his or her opinion on. As a general rule, is that true?
yes.
And the state cited State versus Jordan let me make sure I've got the right one.